Next week, the U.S. Supreme Court will hear oral arguments in a case involving North Carolina election law.
And the thing is with that, the decision in that case could have far-reaching effects on how elections are conducted all over the U.S. WRAL Capitol Bureau Chief Laura Leslie talked to both sides today.
On its face, the Moore versus Harper case is about redistricting, but at its center is a fringe legal theory that critics say could throw elections into chaos nationwide. Earlier this year, the North Carolina Supreme Court ruled that drawing maps for political advantage violates the state constitution. Republican state lawmakers petitioned the U.S. Supreme Court to take up the matter, arguing that state courts don't have the power to intervene in federal elections. J. Christian Adams with the Public Interest Legal Foundation supports that argument.
The easiest part of the case is what the Constitution actually says, which is that the state legislatures have authority over these elections, not state courts, not independent redistricting commissions, but actually the legislatures.
Voting rights attorney Allison Riggs says that's not how the Constitution has been interpreted for 200 years. She said the so-called independent state legislature theory would give lawmakers too much power over all election matters.
The Republican legislative leaders' theory is essentially that the state constitution is meaningless. It is a meaningless piece of paper when it comes to protecting the rights of voters in federal elections. This is extreme.
Attorney Neil Katyal will argue against the lawmakers at the Supreme Court next week.
This case is about checks and balances. What kind of world is it in which state legislatures can do whatever the heck they want when it comes to elections?
Adams, supporting the lawmakers, says the courts aren't needed to check them.
The check on state lawmakers are the people themselves. That's why you have elections for House in North Carolina every 2 years. They can all be thrown out of office.
Riggs says when maps are drawn unfairly, that's not true.
We're talking about partisan gerrymanders that are specifically designed to prevent that check. They are designed not to be fair maps, not to reflect the will of voters, but to produce a specific outcome, in this case, insulating the position of those already in power. It, by definition, can't be that check.
I'll be covering those arguments at the Supreme Court next Wednesday, bringing you live updates from D.C. Laura Leslie, WRAL News, Raleigh.